So if you see a bright red light here, your time is up. The judges actually can see a larger version of this clock on the other side of the podium, so they can see your actual time as well. Does anyone have any questions? All right, let me know if you do. Thank you so much. the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated, please. Welcome to the Fourth Circuit, and our first case today is the United States versus Jacobs. Mr. Kane, we'll be glad to hear from you.
Good morning, Your Honors, and may it please the Court. My name is Kyle Kane, and I represent the United States. I would like to reserve 7 minutes for rebuttal. The District Court should be reversed in this case. The District Court dismissed counts 922G1 and 922G9 as unconstitutional without the benefit of Rahimi, Canada, Hunt, and Nutter. As we now know from this Court's precedent in Canada and Hunt, the G1 challenges are foreclosed. G1 is facially constitutional, and as-applied challenges are not going to be permitted for those. Nutter found G9 facially constitutional, and we think that this Court's holdings in Hunt and Nutter pave the way and show the way and necessarily require that as-applied challenges to G9 should fail as well.
You're going to tell us why.
I am going to tell you why. So,
And is your position that they must categorically fail?
we are asking for a categorical ruling from this Court.
That seems like an odd thing for us to do, right? I understand on G9 that's been resolved, and I understand your argument with respect to, G1's resolved,
correct.
G9 facial is gone, but that's what a categorical judgment is, right? It's a facial challenge. But Nutter seems to leave open the very idea that there could be an as-applied challenge in some set of circumstances.
Yeah.
And I will acknowledge that the district court's rationale here probably doesn't survive Nutter. But we tend to decide cases based on the facts before us. And we don't have any of the facts about Mr. Jacobs. We can surmise some of them. And maybe those are going to be a pretty good reason why his as-applied challenge would fail. But it seems odd to have a decision here when we don't have his full criminal record. We don't know the circumstances of his misdemeanor crime of or domestic violence offense. We don't know what he's done in the interim. We don't know any of the things that would naturally be relevant to an as-applied challenge. And you're asking us to just reject it without any of that information. That seems unusual, doesn't it?
I don't think so, Your Honor. And so I guess we could talk about what an as-applied challenge to G9 would actually look like and the things that a court would want to consider in that. And I think that G9 is interesting for as-applied challenges because the definition for misdemeanor crime of violence in 921 is so specific and necessarily involves the use of force. So or the attempted use of force.
But we know after Castleman that includes like just an offensive touching.
It does.
Right? Like if my wife spits on me, in theory, like she could be prosecuted as a misdemeanor crime of violence. But I mean, we wouldn't naturally think of that as like a particularly violent offense, right?
Well, I agree that it would not be a violent crime, and it's not classified as such. It's going to be a battery.
And so why would she be at risk of, why would she be dangerous and such that she should be permanently disarmed merely because she, happened to spit on me when I said and did things that I plainly should not have said or done?
Well, first of all, this court and I believe the Second Circuit have said that this is not a permanent disarmament. The statute itself provides ways that you can get relief from a misdemeanor crime of domestic violence through expungement, restoration of rights, or a pardon. So it is not a per se permanent ban.
But that's in a facial setting, I think, where that's been said.
It has, but I think that is relevant to an as-applied challenge as well, particularly on on this record where we have no information about that. But it's not.
Do we know whether he sought any of those things?
We don't.
Do we know whether the executive, like, denied them, or he addressed them, or?
None of that is.
I mean,
in
the
this
problem
record.
is, like, the problem I've got is that you're asking us to make this decision where, and I agree, we've got to vacate the district court's decision on the G9 as applied. But it seems very difficult for me to make that decision in the abstract without any of the things that we've described. What, the nature of that I mean, was he convicted of a spitting offense, or was he convicted of, like, physically beating his girlfriend?
That's also not in the record. It was a battery. It was some sort of offensive touching. If I could get back to the initial question that you asked about as applied challenges and what we would be looking at, I think that G9 is.
But your bottom, well, I'm assuming your bottom line is if there's any circumstance that permits this G9 as applied challenge to go forward, that's acceptable to you. But your bottom line, I take it, is that you want a ruling like Hunt where any as applied challenge is categorically banned.
Correct, Judge Agee. I think that that's what is actually required by Hunt and Nutter, because what we know from Rahimi is that Congress has the ability to look at a category of people, make a determination on that categorical basis that they represent a danger, and they can be consistent with the Second
You can
Amendment.
parse the language of Rahimi a lot of different ways, and the decision does say that we're not suggesting that the Second Amendment prohibits possession of guns by category, but at the same token, they didn't say it does. And then when you get to the holding in Rahimi, it's very limited based on a temporal factor. So even though you're absolutely correct, Hunt adopted that categorical approach, which I suspect, among others, Justice Barrett would not agree with.
Yep.
It hasn't gone elsewhere, and the Supreme Court's told us many times, felons are different. But what happens if we took Judge Richardson's example, and those of us who know Judge Richardson well might well understand the actions of his spouse, but we'll put that aside.
In every circumstance.
So let's assume that happens. They're 18 years old. They get she gets some sort of misdemeanor conviction. 30 years go by.
Yep.
Perfect record, citizen of the year, and she happens to be in hunting camp preparing a meal, and somebody asked her to hold the firearm while they pick something up. So she's holding the firearm, and for some reason there's a raid, and she's arrested and charged with the G9. Is that categorically banned without any doubt?
I think it is, Your Honor. I think that is what Nutter says. Nutter
specifically says that doesn't say that.
I think Nutter.
Right? Nutter says that, like, not talking about as applied challenge.
It does. I'm not.
Do you think it was being dishonest when it said that?
No, I'm not saying that Nutter analyzed the as applied. I'm saying that Nutter talked about the temporal arguments, and it does say, sorry, Hunt. I apologize. Hunt talks about the
because
temporal
Nutter
arguments.
talks very specifically about saying on this temporal argument, right? Nutter says, well, we know that there'll be some people that are arrested under G9 in a short time after their domestic violence offense.
Yes.
And so as a facial matter, that means that the temporal issue isn't sufficient to resolve a facial challenge. But by saying that, it necessarily implies that the temporal issue might well be relevant in an as-applied challenge.
It does. So let me talk about what that might look like and where. So if the court were to write that there is some room for as-applied challenges on a temporal basis, I'm not sure where the court would pull the rule for that from. There's nothing in, well, let me cabin the statute for 1 second.
Are you familiar with the Second Circuit's decision earlier this year in Simmons?
Yes.
Because they certainly seem to leave the door open for an as-applied challenge in this circumstance.
I think that they foreclosed.
Now, they say that the defendant, Simmons, offers no basis to distinguish himself from other domestic violent misdemeanors for purposes of assessing this statute. That sounds like to me that there could be some circumstance, maybe theoretical, but they're not adopting a categorical approach.
Okay. So if the court were to want to leave open a temporal thing, it's tough for me to imagine what that rule looks like. And I want to say another word about
Well,
a
but
potential
that's
rule like
typically
that.
why we don't like create rules in a like abstract sense, right? We examine a particular person, right? In our hypothetical of my spitting and hunting wife, right? Like we might well have to grapple with is 30 years of flawless behavior following a spitting conviction in which, you know, she held 30-06, does that like fall within the justifications for disarmament that are put forward by the government? And, you know, we can debate whether it would or would not, but we ought to be debating that in a case where 30 years have passed and it's my wife, right? Like,
So I think that those are great arguments to make policy considerations for the statute to be amended. I don't know that there's
no,
anything
but the
in-
Second Amendment protects the right to keep and bear arms.
It does.
The question is, when can the government take those arms from you? And there's no doubt that there is some set of circumstances for which the government is justified in doing so. Rahimi makes it very clear, right? But Rahimi also very much leaves open, as does Nutter, that those justifications might well, in some case, run out,
Sure.
such that the Second Amendment's protection applies to my wife in our hypothetical.
Sure. And
That's not a policy argument, like, that's a constitutional protection argument.
well, talking about the policy argument, I mean, is like when we're trying to come up with a rule, how long is too long for a conviction to qualify for disarmament? There's nothing in any case right now, there's nothing in the statute that you could pull a number from for that. In fact, Congress did put a temporal limit on a particular subset of these convictions in the statute. 921 has, for the dating relationship, if 5 years have elapsed, you only have one misdemeanor crime of domestic violence against a person in a dating relationship. That doesn't qualify as one of these. So that
Seems to sort of acknowledge the point that there are circumstances in which the justifications for disarmament no longer apply. And Congress has obviously recognized one of those, but your argument is that should be the only one. There can be no other. There's no other factual circumstance, is your argument, that could possibly justify.
there's nothing in any opinion from the Supreme Court or this circuit that sheds any sort of light on what that rule might be. And if I could say a word about what a problem with such a
We've
rule.
asked a lot of questions, so
Yeah.
we'll give you a little extra time, but it seems like to me, the corollary of your argument is that the Congress could have written 922 simply to say, if you do any of these things, you cannot possess a gun, period, full stop, end of story. But that's not how the statute's written.
The statute is written like that for for like a spouse or anyone who's not in a dating relationship. Unless the conviction, you get relief from the conviction through a pardon or an expungement, or you get your rights restored, which you can petition for. But the word that I want to say about what a potential problem with such a rule for a temporal limit on this is it's going to create an additional constitutional and prosecution hurdle with these cases because of the Supreme Court's decision in Rahafe. You have to be on notice, you have to be aware that your conviction, of your status, that your conviction qualifies. And if there's some sort of fact-bound determination that a district court is going to have to make about whether or not this conviction is too old or you've been good enough in the meantime, that I'm not sure how a person would be on notice that they are prohibited.
But you would be
under
on
that.
notice that you're barred by the statute. Rahif requires you to understand that you're barred by the statute.
Correct.
It doesn't require you to know what the constitutional challenge result would look like.
But some person.
So
can
your own notice that you're barred by the challenge, your own notice, you have the knowledge that Rahif requires.
But you would say, I think I fit this exception, and the statute doesn't apply to me, is the problem with a rule, from my perspective.
So the problem, your argument is, the problem with applying the Second Amendment is it's going to arguably, although I don't think so, arguably make prosecution harder. That's the concluding comment that you've got.
No, I would first of all say that is not, that there's not a Second Amendment issue with that. But no, I think it's a constitutional issue for defendants, being on notice of their status related to the Second Amendment. Not, it does create a prosecution hurdle, but I think there's a notice issue to defendants if there's such a rule. I'm way over my time. If there's no other questions, I'd like to reserve.
Thank you very much, Mr. Kane. You've got some rebuttal time. Mr. Moss?
Good morning, Your Honors. May it please the court. This court should affirm the district court's decision that 922G9 is unconstitutional as applied to Jacobs. Here, Bruin step.
Let me
Yes.
make sure that we're all on the same page as what's here. I think you've conceded that facial challenges to G1 and G9 are barred.
Yes, Your Honor, we're recognizing that.
As
although-
applied as to G1 is barred by Hunt.
Currently, Your Honor, yes.
At this
We
time.
recognize that.
All right, so all we're left with is a G9 as applied challenge.
Under the current state of law, Your Honor, I would agree
All
with
right,
that.
so Mr. Jackson, or Mr. Jacobs, was convicted of a misdemeanor domestic violence offense,
Correct.
and you haven't argued that this 5-year exception applies in this case.
That was not argued below, Your Honor. Yes.
Okay. And at the time Mr. Jacobs was arrested, he was in the process of another domestic violent incident, shooting the apartment up with his girlfriend. So why doesn't that in and of itself in this case?
Your Honor, I would say that I think the allegations, that factual allegation laid out by the United States is contested. I don't think Jacobs was never convicted of that domestic violence offense that's alleged, nor was there any judicial
Well, is there any
determination
place
he
in the
engaged in.
record, is there any place in the record where that's contested?
I believe it is contested in the record insofar as they were arguing that the as-applied challenge should succeed in this
Now,
case.
what I'm looking for is someplace where he or counsel says, I didn't shoot the apartment up with my girlfriend in it.
I would say that the record
He
is.
pled not guilty.
Correct.
Right?
Your Honor, and there's been no judicial determination of guilt in that case.
Did he waive his detention hearing?
I don't even, but at the time that this 922G9
I know, but
case,
start with the answer and then give me an explanation. Did he waive his detention hearing?
I wasn't his attorney below, Your Honor.
Okay.
I believe that the government did not move to detain him. I believe he was just on bond for the 922G9 charge. The domestic if there was a state charge for that domestic violence that the
So
government.
you think
alleged started this case,
he was not detained? You just don't know
I
whether
don't
he
know,
was
Your Honor.
detained or not.
But I do believe that for the federal case, he was not detained. I could be incorrect on that. Again, I was not.
Can you tell me what about Mr. Jacobs in particular, except for a minute that the argument about spousal abuse that the district court adopted is not a persuasive one. But what about Mr. Jacobs in particular takes him out of the heartland of the domestic violence disarmament statute? So what about him makes him sort of like my spitting wife who likes to hunt after 30 years of exemplary service, right? Why is he more like her than what you would think of as the core justification of a repeated domestic violent defendant.
So, add to that, in the words of the Second Circuit, what basis distinguishes Mr. Jacobs from other domestic violence misdemeanors?
This predicate misdemeanor was approximately 12 years old at the time of the federal indictment. In the interim,
How do we know that, by the way?
I believe it was stated that in the record, in the joint appendix, that he was convicted in 2013.
Okay.
Um,
So we know it was 12 years old.
Yes.
What else do we know about that prior conviction today?
I don't think we know anything else about that prior conviction today, Your Honor, except that he did not sustain a subsequent misdemeanor domestic violence conviction within the interim 12 years. I think that indicates rehabilitation.
Right, but was arrested at the end of the 12 years in an alleged domestic violence scenario.
Correct, Your Honor, but there's no,
And
again, no
do you think-
judicial determination of guilt there.
Right, but you agree that you bear the burden of showing the as-applied challenge, right? And so you have to show, the fact there's been no determination is something, but you've got to show that your client is unusual. He doesn't fall in the heartland. And to say, we don't know anything about his conviction, and yes, he's been accused of possessing a firearm in the process of committing domestic violence, like, neither of those things, like, really, like, help you establish that your client is outside the heartland.
Let's look at Jackson, Nutter, Gales, Simmons. We know Jacobs has one misdemeanor domestic violence offense that is approximately 12 years old. He's not a two-time domestic violence convict like Jackson in the 10th Circuit, not a three-time domestic violence convict like Nutter in the 4th Circuit. He's not a serial perpetrator of domestic violence like Gales in the 6th
Well,
Circuit.
a serial might, I don't know. I mean, we don't yet, it's true, we don't have an adjudication with respect to this second domestic violence event, but like, we've got the allegations of it, and so he might be a serial domestic abuser, right? My problem is, you've asked us to affirm, your colleague asked us to reverse. It seems like to me, we just don't have enough information to evaluate whether, and seems like to me, you got a pretty steep hurdle here, but it seems like to me we lack the information about the prior conviction. We lack information about what he's done over the last 12 years. It seems, with the very limited information we do have, that he's not been a model citizen over those 12 years with respect to other criminal offenses. And we know that the allegations under which he's arrested, that seems to probably put him right in the heartland of these cases, but all of that's a little supposition because we don't have any of those facts.
That's correct, Your Honor. We don't have a record that I believe would allow me to answer that question completely. However, what we do
you know whether the first domestic violence offense was against a non-girlfriend, like a spouse or a child?
I don't believe that's in the record, Your Honor. The record is sparse, Your Honor, and I think that here at the outset, if we look at the joint appendix, it suggests that the United States failed to meet its burden in showing, this is going back to Bruin Step 2, that 922 G9 as applied to Mr. Jacobs is consistent with the nation's historical tradition of firearm regulation. I think consistent. Yes,
Let
Your
me
Honor.
ask you about, how is it, in looking at Rahimi, in a few courts have said that the historical analog under G8 translates to G9. Why is that not the case?
Your Honor, I think there are multiple reasons why the historical analog under G8 does not translate to G9. Particularly because, as Rahimi notes, that G8 is temporary in nature and it automatically restores one's right.
There's no conviction there.
Correct. Your
Well, there's
Honor.
no conviction, but also in Rahimi, it says we are looking forward, looking in terms of any violence, which, of course, your client is arrested for another domestic violence charge.
Yes, Your Honor. G9's force element looks to the past conduct. G8 requires a present judicial determination that the individual poses a credible threat of physical safety of another. And if we look with regards to the record, which understandably is sparse, as applied to Jacobs, there's no judicial finding of present conduct, and the past conduct, the record does not indicate whether a firearm was used. It doesn't not indicate anything, but I think what we can surmise from that is there's no actual evidence
Right,
to
but
expect that
as
he
you
might
were
misuse a
going over
firearm currently.
with Judge Richardson, I mean, the government's burden was to show there was a prior domestic violence conviction, there was, and that he possessed a firearm after that conviction. They did that. So then it seems that, as Judge Richardson indicated, it was incumbent on you to show that something in that intervening time period sets him apart. You know, he won 6 Nobel Prizes, whatever it happened. Or there was some peculiar aspect of this case, which there doesn't appear to be, that would establish a basis to differentiate him from other domestic violence convicted offenders. And there's just nothing in the record I see that does that.
The record is sparse, Your Honor, and I think part of the reason is that the court ruled that the government did not meet its burden in this case. And I would note that if we look to the joint appendix and we look to the record in
Well,
this case, it does
did-
not
did-
appear that
right,
they
it did
argued
that,
going
but
armed.
It did it based without the benefit of these other cases we've been talking about today. And I can understand, you know, after Bruin, there's been a lot of confusion. In some respects, the Supreme Court didn't do us any favors. But, you know, now that you do have the benefit of these other cases, there doesn't seem to be much left of the actual reasons used by the district court.
Well, Your Honor, Bruin makes clear that the district court they're entitled to decide a case based on the historical record compiled by the parties. They're not obligated to sift through it. That's the government's burden. If we look at the joint appendix, it does not appear
Right,
that
but the government, you've already acknowledged, the government met its burden in this case. It presented its case in chief. And then, once it's done that, it's incumbent on you to show why there's some sort of an exception here other than a decade has passed. That seems to be your only argument from the record.
Your Honor, I don't believe they did meet their burden because I don't believe they ever identified going armed laws as a relevant historical analog.
Counsel, here's the rub, right? So you want the government to have to meet Bruin Step 2 with respect to G9. The problem is, like, Nutter's already done that, right? And so you're right, if this was the first case, we might well hold the government to their burden at Step 2. The challenge is like, Nutter's already done that. And what we don't get to do is hold the government to its burden each time it comes up. We have made the determination, right or wrong, based on a legitimate historical record or not, right? We've made that determination, right? And the district court relied on sort of a different historical record with respect to spousal abuse that is flatly inconsistent with Nutter. So we have to say like that doesn't work, and that in fact the government has met its Bruin Step 2 burden with respect to G9 as a facial matter. And then the question is, how do you take yourself out of that with respect to an as-applied challenge? And that's not the government's burden now, right? It's now your burden to show why you are not within the heartland of those cases, right? And so I look at this record, and I understand you were arguing, and the district court was addressing this in a time when they lacked the guidance they have now. And so it's a little unfair for us to, you know, we're certainly not criticizing the district court, but we now have to decide it based on the record we have before us. And that would require your client having some reason to establish that they're outside of the norm. So I don't think you've got a Step 2 government's burden issue here.
Understood, Your Honor, and living with the record as it is, what we can say is that this conviction was 12 years old, so I do think that there is that temporal proximity argument. We can compare what we know from the record of Jacobs to what we know from the record of Jackson, Nutter, Gales, and Simmons. And all of those individuals had much greater criminal history than Mr.
Well,
Jacobs.
do we really know that? Because we don't really know Mr. Jacobs' like actual criminal history, do we?
I
Like,
suppose we know
do
the
we
criminal
don't-
history on the record. We know that
Right, but we don't actually know what his criminal history was. We don't actually know anything about the initial conviction, right? We don't know what he's been doing in the interim, right? We don't know the volunteer work he's done, or the employment history, or the whatever else it is you want to include. We could think about all kinds of things we might include. Sort of why I thought what you were gonna say is, all right, fair, the district court's reasoning doesn't work under G9 as applied. But what you ought to do, given the development in the case law, is vacate that decision and remand it and let the court figure out whether Mr. Jacobs is such a person, or, as frankly it appears with the limited information we got, Mr. Jacobs is not such a person who could legitimately bring an as-applied challenge.
Your Honor, I contemplated that. I believe that would be a fair result. My position is that Mr. Jacobs would prevail on an as-applied challenge, even based on the record as is. But I understand that, obviously developing a record in this case would be helpful, arguably to both parties. I would note that I agree with Your Honor that as-applied challenges 922 G9 do remain viable post Nutter, Hunt, and Rahimi. I don't think that any of those cases frustrate that position. Given the sparse record, if the court has no other questions, I have no further argument.
All right, thank you very much, Mr. Moss. Mr. Kane, you have some rebuttal time.
If I could start with some JA sites that kind of go to some of your questions for Mr. Moss. In the JA 24, I include some facts about the altercation. Mr. Jacobs did.
Hold on a second, counsel, let me catch up with you, if I can. Okay, 24.
Yep. Mr. Jacobs submitted to a custodial interrogation, waived Miranda rights, and admitted that a firearm was discharged. He said it was an accidental discharge, but he admitted that a gun went off during the altercation. Then going...
Did he admit that it was a domestic violence discharge?
He admitted that he was in an altercation with his significant other and that a firearm went off, but it was accidental.
Was he married to this significant other
He
or
was not married to this individual.
Do you know whether he was married before? In particular, was he married 12 years ago when he was convicted?
So I don't recall, but what I can tell the court, it's not in the record, but legally.
Then don't tell me.
No,
If
but
it's not in the record, I don't want to hear it, right?
But legally, I can tell you that the statute was amended to include the dating relationship after 2014. So a 2014 conviction legally would not qualify unless, if it was a dating relationship. So it would have had to have been one of the other categories. It would have had to be a spouse, a child, one of the other categories of misdemeanor crimes of domestic violence.
If we assume that you got it right.
Well, fair enough, Your Honor.
Right, I mean,
Yeah.
I'm not impugning you, right? But like, it's just like a lot of assumptions here that
fair
we're
enough.
building into what's going on.
JA pages 3 to 4, Mr. Jacobs was detained in this case. I don't recall if he waived detention or had a detention hearing, but he was detained in this case. And then also going back to JA 24, it was not 12 years. I'm not sure how much of a difference this makes, but the conviction was 2014. The offense and the indictment were 2023, so it was 9 years from conviction to offense to indictment. And as we sit here today, it's been 11 years since that.
From
that
conviction to indictment, but offense conduct date was the 12-year date, right?
No, it was 9 years. The
The
offense was,
conviction or the offense conduct, right? Because the conviction happens after the offense conduct, right?
so I don't know the offense conduct. It would have been the specific date. It was a misdemeanor. in magistrate court, it would have been very quick. It would have been months, not
Maybe.
years.
Maybe.
It would have been.
All right, but
So-
the challenge I've got is like, maybe,
Yeah.
I mean, not that I'm not saying I don't trust
Yeah.
you, but that seems like a thin reed for me to rely, is that your experience
Oh.
with magistrate court.
I can, actually, the case number is in there. It's a 2013 case number, so the offense conduct was 2023. Or 2013, sorry.
2013.
2013. It's case number 13M4257, so 2013. So then, to address Judge Benjamin talking about G8 being distinguishable, the reason G8 is a temporary restriction is because the order itself that causes the prohibition is temporary. As soon as that order is lifted, the prohibition goes away. So necessarily that has to be a temporary restriction. I think that the opinion in Nutter has, this court has parsed the temporary, the temporal arguments and found them unpersuasive, at least on the facial challenge. But I would then point the court to JA 64, and this goes to the defendant's burden on an as-applied challenge, and also some of the things that we talked about earlier about what's, the difference between a facial and as-applied challenge in this context. And the court, starting at line 13, the court was not clear from the briefing whether defendant brought a facial or an as-applied challenge. And Mr. Compton actually had to confer with his client about what they were bringing, and then said that it was both. And he said, I think the arguments are frankly the same. And I do think in the G9 context, because the definition of the misdemeanor crime of domestic violence is so specific for who qualifies, what kind of offense had to happen.
I mean, so specific, right? It includes spitting and like beating, right?
does.
I mean, it includes like a wide array of things. It includes intentional conduct, but it also includes reckless conduct.
We know that from Voisin.
Right? And so when you say it's so specific, that seems like odd. It might have been thought specific pre-Castleman and Voisin, but
Yeah.
it's hard to say it's so specific today.
Well, it's specific as to the offenses that qualify. So I think to the extent that there is room for an as-applied challenge, I think the temporal arguments are where that work could be done. I think that.
Or in the nature of the offense, right? If it's purely reckless, like spitting.
Yes.
Right? Imagine if there was a reckless spitting and that resulted in a domestic violence misdemeanor, we might wonder about whether that falls in the heartland of the justifications for disarming folks, right?
Well, I think Voisin has said that. I would also say that reckless conduct can also be a felony, and this court in Hunt, isn't doing felony by felony litigation, and I don't think the court should get into that business in the domestic violence
Well,
context.
of course, that's in a felony category, which the Supreme Court's been pretty strong on in all of its decisions. But starting on page 64, where there's this discussion about, well, what type of challenge is it? And only a few pages later, the district court goes on to rule as to historical tradition and that sort of stuff. So there really wasn't, and I'm asking you, there really wasn't an opportunity or a need, based on what the district court did, for the defendant to proceed further to put on any additional case with regard to the record. I mean, it had already been ruled as a matter of law that he was free to go. This wasn't an offense. So, a lot of times in that circumstance, if we see, well, there was a legal error, we will vacate and send it back to the district court, and you can put on whatever additional evidence there is they want to put on. But once the legal error is corrected, the district court in the first instance goes on and adjudicates on the full record once there's the opportunity to make that record.
And if that's the way that this court sees that, then I would ask.
Well, I mean, wouldn't you agree that in, putting aside the firearms part of this, in a lot of cases, that's exactly what we do?
Yeah. To be perfectly frank, it's unclear to me. I think it's very intertwined whether or not the district court ruled that G9 was facially or as applied failed. If I'm recalling the record correctly, I know I asked that specific question as to G1.
Right, but I take
But-
Judge Agee's point to be, if the district court finds as a matter of law that it's facially invalid.
Correct. And
Then you don't then sort of say, well, Judge, we need you to make an as-applied ruling too.
yeah, and that's what I'm saying. If that's the read that the court has, I think that's fair. And I think you just don't address the as applied then and remand it to the district court to make a finding that the court can examine if it's going to leave that open. So if there's no further questions, I would ask you to reverse the district court and remand for proceedings consistent.
All right. Thank you very much. We appreciate the arguments of both counsel, and I know, Mr. Moss, that you were assigned outside of your normal duties, so to speak, and that the court's appreciative of you undertaking that task. So we're going to come down and greet counsel, and then we'll move to our next case. Fitchen, did I pronounce that correctly? Yes, Your Honor. Please come on up, and we'll be glad to hear from you.
Thank you. Good morning, Your Honors. May it please the court. The issue in this case concerns Virginia's tuition assistance grant program, and that program's provision that withholds the grant to otherwise eligible students if their majors involve theological and religious vocational majors. Excluding such students like Ms. Hall is a quintessential free exercise clause violation. In holding otherwise, the district court relied on Rodriguez de Quejas's explanation that even if a case has been undercut somewhat, it's the Supreme Court's prerogative to say that, and lower courts cannot. And the case they were talking about was Locke v. Davey, which involved a similar scholarship program from the state of Washington, reached the Supreme Court back in 2024. If that's true, then Locke is still good law, and that's why we've briefed it both ways, and mainly acknowledging Locke's existence. It has not been explicitly overruled. But in recent years, the Supreme Court has taken almost a contrary tack to the Rodriguez tack, and that is holding courts responsible, lower courts, courts of appeals, to recognize erosions of cases, changes in jurisprudence. And the two main examples we have of that is the Lemon test being overturned in Kennedy versus Bremerton School District. And Justice Gorsuch, in his analysis, in his opinion, spent a lot of ink on what had happened at the Ninth Circuit when a petition for hearing en banc was denied, and he talked about the points that the dissenters to the denial had made. There, Justice Gorsuch quoted the dissenters to say that Lemon had been effectively killed. They didn't use the language of it's been overruled, but effectively killed. and also the language from the dissenters that many courts had recognized its demise and left it for dead.
Well, let me ask you this, but it seems like in reading Espinoza and Carson and those cases, the Supreme Court seems to distinguish those cases from Locke.
Yes, Your Honor, that's true. And in doing so, they really abandoned the rationale, in all three of those cases, they abandoned the rationale of the Locke majority and embraced the rationales of the Locke minority, the two dissents. It's true, however.
Not the dissents, I'm talking about the majority. It seems as if they recognize Locke and
Yes.
they distinguish the cases from Locke. In
Yes.
in their analysis, why this case is not Locke.
Well, if this court decides that Rodriguez is still in force, then it is. Factually, it's on all fours, and we've briefed it that way. We're not running away from those similarities. What I was trying to say, though, about Trinity Lutheran and Espinoza and Carson is that the majorities in those cases actually embraced the dissenting views of the Locke case. But ironically, this seems mutually exclusive, and yet this is exactly what they did. They did distinguish it. They did not overrule it. And we can speculate the reasons. I don't know if that's helpful or not. In Trinity, I can tell you that Justice Thomas said he did not address it because no party asked them to
Right.
overrule.
I mean, you may well have a winner at the Supreme Court, looking at the trajectory of some of these cases, but as Judge Benjamin indicated, in each one of these three later cases, the court has gone out of its way, in contrast to any of the Lemon-related cases, to say, Locke is still there. And there's no language in any of those cases that, to me, implies that it's been left for dead by the side of the road. They very specifically carved it out. So it seems like to me, as a lower court, we may agree the tea leaves show that you might have a shot at this, but I don't know that we've got the ability to give you that shot.
Yes, I understand, and that's why we have, as I say, we've briefed it both ways. I think that the problem for courts, not just this court, is my second example, which is Medina, which came out of this court. And this,
Some of us are familiar.
yes, with a concurrence perhaps, Your Honor, and others as well. But this court did not quote Rodriguez, but it quoted Hahn for the exact same proposition. That, in vertical stare decisis, it's for the Supreme Court, it's their prerogative. And this court walked through very detailed analyses of Wilder and Wright and Blessing and said, we think our hands are tied. This is not for us to do. But the concurrence did say it'd be helpful if we got some guidance from the Supreme Court. The court took the case and said that this court, and I think it was 2 or 3 other courts of appeals, should have recognized a prior repudiation. And so,
Doesn't quite say that we should have recognized the prior repudiation. The oral argument certainly suggested that, and you might imply that in the opinion, but he doesn't actually say that the lower courts should have done this.
well, they said that you're right, they talked about
It's
the
a little,
repudiation.
it's a little cute, right? I will confess, I have no idea what we're supposed to be doing in these kinds of contexts. Because the court, in cases like Mallory, it's not like they just cite to the old cases. Mallory says it's the Supreme Court's own prerogative to overrule its cases.
Right.
And yet, I think certainly in both of these cases, there's a suggestion that maybe that's not always true. But it's a little hard for me to figure out how to do that.
Yes, Your Honor, we're right there with you. That's why we briefed it both ways. And to me, it's very interesting that they sort of praised the dissenters in the en banc in Kennedy, dissenters from the rehearing en banc, the language I used before, effectively killed. That's not overruled, but they,
It's easy to say in a dissenting opinion that Lemon's no longer good, right? Because you're dissenting, right? So you get to say what sort of you don't want to there. But when you're acting on behalf of the court, that's a little bit of a different ballgame.
Oh, certainly, Your Honor. My point, I'm sorry if I wasn't clear, but that was the judges who dissented from denial of the rehearing. But I'm addressing the fact that Justice Gorsuch, when the case got to the Supreme Court, spent a lot of ink on the dissenting opinions, and he picked up on their language. He said, look, courts have noted this. So we have Kennedy, which does what I described, and we have Medina, which does what I described. None of them, they don't talk about Rodriguez or Hahn, but Mallory was between those two. So they don't talk about it, they do talk about it, they don't talk about it. And again, we recognize, as litigants, we're in a comparable position to where you are as judges. It's what's the Supreme Court going to do next? And so we said, you guys, excuse me, I shouldn't say you guys, this court doesn't have the authority to overturn Locke if Rodriguez and Hahn is still good. But if the court's attitude, the Supreme Court's attitude is more like it was in Medina, then, what's a court to do?
But we also have more recent cases like Boyle and others that fairly strongly tell us that vertical stare decisis is still a thing, right? I mean, it feels like a little bit of a hard story here when the court says, last year in Boyle, our decisions bind lower courts, right? And so, which is sort of the Mallory line, rather than what you've described as the Kennedy or Medina line.
Yes, this court already twice this year, I didn't check on Hahn, but twice this year, this court has cited Rodriguez for that proposition. Checking across courts of appeals, that seemed pretty typical. A couple times a year, courts of appeals are recognizing what Rodriguez says. But Mallory is the only case that the Supreme Court has done it, going back about 3, 4, 5 years. And again, it was between Kennedy and Medina.
It didn't cite it, but it said the same thing in Boyle, right? I mean, it says that our decisions continue to bind. Even unreasoned decisions continue to bind.
Yes, I mean, yes, they don't have to cite Rodriguez because there are other cases. I think Mr. Fleming, in his briefing, also mentioned Agostini for the same proposition. This court has used Hahn, so yes, it doesn't have to be Rodriguez. I'm not saying that, but that proposition, and yes, it's a rock and a hard place. It's courts are on the horns of a dilemma, and so that's exactly why we briefed it both ways. But going back to Trinity and Espinoza and Carson, they cabined it for whatever reason. They relied on rationales that were from the Locke dissent, as I mentioned previously, not from the Locke majority, and yet they said, but Locke still is there, and we're going to distinguish it. As Your Honor said, they did literally distinguish it. They did not overrule it, that's for sure.
And what is your argument, are you making an argument, or what is your argument that if this court were to follow the Mallory line rather than the Kennedy-Medina line, that your client is distinguishable from Locke? Is there an argument that if we applied Locke as it stands, that your client somehow is different enough that it shouldn't matter?
No, we are not distinguishing it. In the complaint, we recognize that her major is one of the theological and religious vocational majors.
I mean, it's a little different, right? I mean, her major, I don't, sort of hard to cut lines here, but you might think of the music ministry as a little different than sort of the direct minister line. Is there anything to that?
Well, at a common sense level, there is. I don't think there is legally.
And why not? Why is that not right, I've just said it happened on Tuesday versus Thursday, and you're saying the day of the week doesn't matter, but why is it that you think her major in particular is legally the same as the theology major in Locke itself?
Because the purpose of the major is to prepare students for theological vocational careers. And that's certainly not limited to what we think of as the preacher or the ordained clergy. Music ministers, choir directors, they instruct a lot. I mean, this is not anything in the record, but just as you asked it from a common base point, from a common base answer, they teach, they instruct. Music itself has incredible theological content in many church traditions, and so.
But the, the chief's sort of discussion, again, taking it for what it is, in Locke, you might say it really is limited to ministers, right? I mean, the historical discussion he has, he doesn't refer to it, or maybe I don't remember him sort of referring to it as like anything that you might do that involves, theology, right? But it's really sort of seems to be more focused on ministers.
Yeah, there's no doubt the historical analysis was, because of the early national history. But
But for purposes of this case, in effect, with regard to the questions Judge Richardson's been asking you, you've conceded both in writing and here today that there is no difference.
correct, yes, that's right.
Factually.
Okay, and so, basically, I guess this court has two options. If you thought we need to consider Medina, then you could rule that way. You could say, no, Locke's no longer good law. But if you say, no, we're not going there, we're doing the Mallory thing, and it is still good law, then what we would request is that you would issue an opinion expressing your own concerns about Locke to the extent that you have them, and ask the court, say that we hope the Supreme Court may take this case, declare Locke no longer good law, as we would hope, or of course the opposite. The court has already done that once in Medina. The guidance was asked for, guidance was given. And so those would be the two opinions, that Locke is abrogated, it's functionally abrogated, or we understand there's problems with Locke and we would encourage the Supreme Court to grant cert. Any further questions, Your Honor?
All right, thank you very much. You've
All
got
right.
some
And I've reserved 5
rebuttal
minutes for
time.
rebuttal. Yes. Mhm.
All right, Mr. Bernhardt.
Good morning. May it please the court. In Locke versus Davey, the Supreme Court addressed the exact issue that is brought before this court in Ms. Hall's lawsuit. In it held that states do not violate the free exercise clause of the First Amendment when they decline to provide funding for post-secondary students pursuing religious vocational degrees. The Supreme Court has never overruled Locke. And in this trio of recent free exercise cases, it has instead distinguished Locke from those state laws that it has struck down, primarily because of the substantial, the historic and substantial state interest in not providing state financial support for religious leaders.
So I take it then your view is what you've just expressed ends this case for purposes of the Court of Appeals.
Our view is that this is a very simple case for this court, that Locke directly applies, and that this court should simply affirm because the district court applied the case that directly applies to the facts, which Ms. Hall's counsel has conceded in writing.
So tell me how you understand Medina, right? Because we've got this set of cases, Wilder, Blessing, that were not ever expressly overruled. They were indeed cabined and limited, just like we have here with respect to Locke versus Davey. They had been seriously undercut, but had not ever expressly been overruled. And both in the opinion and also in the oral argument, the Supreme Court was very clear, I think, in saying that, the lower court, this court, should well have recognized that those cases, Wilder and Blessing, were no longer good law. It feels a little bit like this is the same story, right? I can imagine writing the same opinion that says, my hands are tied, and despite Kennedy and its discussion of Lemon, and despite Medina and its discussion of Wilder and Blessing, I'm going to continue to follow Mallory and on in those lines of cases. And the Supreme Court saying, like, come on, guys, y'all got to recognize the writing on the wall. Tell me why, like, that's not the best reading of Medina, and that I should continue sort of fumbling down this path where I profess to have no ability to do something, and the Supreme Court continues to say, you do not only have the ability, but you should be doing it.
Judge Richardson, I think it's a different history that's presented by Locke and how the Supreme Court and lower courts have treated the Locke decision. I think comparing.
I don't really care how the lower courts have treated the Locke decision, right? I really only care about how the Supreme Court has treated it, right? Whether my colleagues have gotten it right or wrong is a little bit neither here nor there, right? The question I've got is, has what the Supreme Court's done since then seriously undermined Locke? Yes, right? I mean, I think that's like hard to argue with. The question is, has it sufficiently done so that I can, say that it has been effectively overruled?
And the answer is no, and I think that how the Supreme Court treated Locke in Carson versus Macon is very instructive. When Maine attempted to rely on Locke, the Supreme Court explained, Locke cannot be read beyond its narrow focus on religious vocational degrees. So they're saying you can't apply more broadly to separate historical traditions as it relates to state funding for primary and secondary education. But as it relates to religious vocational degrees in the post-secondary area, Locke is still good law. And they're doing that because Locke was based on a separate historical precedent. I think that's
Okay,
very different
so
from
then
how-
why don't I take the Bivens line of cases, right? And say, in effect, any factual distinction, whether it's material or not, any factual distinction means that Locke doesn't apply, right? That's sort of what the court has done in the Bivens context. So they've said, if you can just come up with some factual distinction, and I've got a factual distinction here, right? Because Locke did not involve music ministry, and music is different. I don't exactly know why, but that doesn't matter. There's a distinction. And so in the Bivens lines of cases, the court seems to say, as long as there's a distinction, it doesn't really have to make a difference. And so why shouldn't I take that approach to Locke? Just limit it immediately to its facts. I mean, run it down, as much as I, in fact, it might only be limited to cases from the West Coast, right? If you're not a West Coast state, then I'm not going to apply Locke, right? Sort of east of the Rockies, no Locke.
I think how the Supreme Court has, what they've said is Locke applies to religious vocational degrees. There's no question on this record, and the parties don't dispute that Ms. Hall is pursuing a religious vocational degree. So there's just no grounds to distinguish.
I would just say it's a vocation in music, and it happens to be, in a religious setting, but, I think its primary focus is music, not religion. So I think that's enough of a distinction to sort of say Locke remains good law so long as you're from Washington State and you're a minister.
And I understand, I appreciate that argument, Your Honor. I would just point out that Ms. Hall, her actual degree, as indicated in her complaint, is that it's music and worship with a focus on youth ministries. There is a focus on the ministries, which Mr. Davey also was pursuing a degree in theological ministry. He was seeking to become a minister. And
Right, but
again,
we say adults and kids are different all the time, right? And so the fact that she's doing music to kids is very different than being a minister in a pulpit to adults, right? I mean, that would be enough of a difference in the Bivens context, wouldn't it? I mean, the fact that it's a somewhat different context would suffice in Bivens, right? That involves kids would be more than enough to distinguish the Bivens case.
And Judge Richardson, The Bivens line of cases hasn't been briefed in this case, and I'll just be candid, I'm not familiar with it, so I can't speak
Fair
to
enough.
that. Turning back, I think how the Supreme Court in Espinoza versus Montana Department of Revenue, how it distinguished Montana's law from Washington's law is instructive. So it noted when it's striking down the Montana law that the Montana law prohibited state funds from going to religious schools because they're religious. And they contrasted that with the Washington law, which did allow state funds to go to students attending religious
Yeah, because
colleges.
in Espinoza, they go on and say, well, you may go to a religious school, but that doesn't mean you're pursuing you may end up being a doctor, a lawyer. They don't use those exact examples, but this whole, what you plan to do with it versus what it is.
Correct.
Right.
But the court in Espinoza also noted that there's different historical traditions, and that at the founding era in the early 19th century, states apparently did not have a problem with providing state funding to primary and secondary religious schools. In contrast, the historical tradition articulated in Locke is that at that founding era, states very much did have a problem with state funds going to support the education of religious leaders. And so there's just different historical traditions that the court pointed out in both Carson and Espinoza, in saying these states can't rely on the same rationale that existed in Locke to prohibit funds from going to primary and secondary religious schools.
Do you contend that Locke got the history right? Do you think the history's right?
From what I'm not a historian, Your Honor, but it appears to be, and I haven't seen a subsequent Supreme Court case challenge that. And I think what the Supreme Court in Espinoza noted is that states, even states that had an issue with providing financial support to the clergy, did not have a problem with providing that support for the primary and secondary education. So it was looking at,
Were any of the problems with generally applicable funding as opposed to specific funding for ministers in the historical record? You can say, I have no idea. This
I
is
don't know,
not
Your
totally
Honor.
a fair question, I acknowledge.
just to circle back, I think, to the issue of the Supreme Court's treatment of the Lemon test in Kennedy versus Bremerton, I think what's different from how the Supreme Court has treated Locke is that prior to Kennedy versus Bremerton, in American Legion versus American Humanist Association, the Supreme Court cataloged a number of times that it had explicitly declined to apply the Lemon test or had just outright ignored it. And also, it appeared in the record that lower courts had recognized that the Lemon test had been abandoned. That's just not the Supreme Court hasn't had a similar to what it did in American Legion about Locke, and I haven't seen any lower federal courts that have essentially read the tea leaves and said that Locke has been essentially overruled. I don't think, as my colleague on the other side has noted, they're not disputing that Ms. Hall's case is on all fours with the facts with Locke, and as our briefs point out, I don't think they could do so. Both cases involve undergraduate students at private Christian colleges who chose to pursue religious vocational degrees, and then as a result were denied state funding because of that choice in degrees. And both brought similar challenges alleging that those state laws violated the free exercise clause. However, both Virginia and Washington laws allowed state funds to go to private religious colleges and to go to students who were taking courses in religious and theological studies. So again, I think this is a straightforward case for this court. We have a Supreme Court precedent that directly applies, is on all fours, and lower federal court should simply apply this. So unless there's any further questions from the court, I would just conclude that as Locke directly applies to Mrs. Hall's lawsuit, the district court correctly granted the motion to dismiss for failure to state a claim, and this court should affirm.
All right, thank you very much, Mr. Bernhardt. Mr. Fitchen, you want to tell us anything else?
Yes, Your Honor, just a few points in rebuttal. My friend on the other side spoke briefly about Carson. The interesting thing about Carson is it serves as a good example of what I was mentioning before, where the majority in Carson actually went with the rationale of the dissenters in Locke. For example, the majority in Locke said, this is only a mild imposition. Carson says there's no such thing. Any loss of First Amendment rights is not a mild imposition. And so I just wanted to, in response to what he was using Carson for, just make that point. That's an illustration of my prior point. The question regarding is the historical record correct? I guess the non-answer is partially yes, partially no. But one real problem with the historical record, in addition to talking about things like do they support schools and yet not want to fund clergy education, there was a lot more to the history there, and which I think is one of the major problems with Locke, and that is something that Justice Thomas pointed out, which is a lot of that analysis was about the Establishment Clause. And the point that there is no Establishment Clause claim, or should not have been in Locke, and there is not here. And when the Establishment Clause jurisprudence is imported into a free exercise claim, it really taints the analysis. And so it's very important historically to remember that there were established churches, and so the Establishment Clause should have been irrelevant in Locke. It should be irrelevant here. In addition to the question about the music versus the clergy, this is something it sounds like my friend on the other side and I agree on. It could be distinguished that way, as we spoke before, but I don't think it should be, because the overall the overall exclusion is vocational careers in ministry and theology. And so by way of analogy, this is very much what's at issue with the ministerial exception cases. Well, are the pastors, the preachers, the rabbis different than a teacher and down the line? And we believe that doctrines like the ministerial exception, the doctrines that have been expressed in Carson and Trinity Espinoza, with the caveat, not overturned, those doctrines are designed to protect the most people. And so we really believe that this is a free exercise violation of someone with a religious, albeit musical, but religious vocational major. And so we think that is one of the major problems with Locke and with the district court continuing to rely on Locke. So I believe that's what I have that's in rebuttal. There are many other problems with Locke, but that's trying to be responsive. So.
All right, we thank you very much. My guess is that either you all or somebody else is going to have the chance to make this argument again, regardless of what we do. So
I think so, Your Honor.
a good job by all counsel. We're going to come down and greet counsel, take a very brief recess, and then move on to our last case.
The Honorable Court will take a brief recess.
you're ready to roll.
Good morning, Your Honors. May it please the Court. This appeal presents the purely legal question of whether a single unforeseeable inmate-on-inmate assault can support the denial of qualified immunity and a Monell claim under 42 U.S.C. Section 1983. The district court answered those questions, yes, but that answer conflicts with settled precedent from the Supreme Court and from this circuit. The district court applied the Eighth Amendment to deny qualified immunity to officers Berry and Linster, and then the 14th Amendment to sustain the Monell liability claim against Sheriff Blackwood. Neither standard supports liability in this particular case. Under the Eighth Amendment's clearly established law, qualified immunity cannot be overcome without proof that both defendants
So
Berry,
now, are you representing everybody, the individuals and the sheriff? Okay.
I represent all of the defendant
All right, all right.
appellants, yes, sir. So, under the Eighth Amendment's clearly established law, the qualified immunity cannot be overcome without proof that Berry and Linster were actually aware of a specific serious risk to Mr. King and chose to disregard it, and on the record, we do not have those facts. The court, looking at those facts in the light most favorable to the non-moving party, misapplied the law and found that it was.
So is it your understanding that the harm at issue is the inmate beating, the asthma, or both?
Is the serious medical need. Officers Berry and Linster recognized that serious medical need to be the asthma when Berry entered the cell, but the court looked at it in the narrow sequence between the time that the last round had been done and then Berry entering the cell, and there was a 25-minute lapse there. But what the appellee.
So let me just stop for a second, because the rub that I've got here, you keep saying asthma, but the district court found that they suspected that he had been assaulted.
There was a statement after the fact from.
No, I'm talking about what, because we have the challenge that we don't get to review those factual findings.
Correct.
Right? The nature of the posture here, interlocutory appeal, is that we have to accept the findings, and it seems like the district court made an actual finding that they suspected that he had been assaulted. And so, I guess, help me understand why I don't have to accept that fact, right? With respect to the knowledge that they had, 24 minutes or 20 minutes before they went into the cell. I take the district court, and I might not agree with it, but it doesn't matter. Don't I have to take as a given that they suspected that he had been assaulted?
Yes, Your Honor,
There was sufficient evidence from which a jury could conclude that he was assaulted.
that is what the district court concluded, and we are bound by the facts that were conclusively found below. The error is in the legal standard was applied because it was not clearly established in 2020 at the time that Berry and Linster were involved in this incident that Mr. King was entitled to thorough security round checks.
What about the medical necessity, though? I
The
mean,
medical
because the
nec-
district court looks at it, I know you're trying to lump them together, but she looks at the safety, and then she looks at the medical, the health and safety, and then the medical need.
Well, the court granted summary judgment as to the failure to protect claim. So on the serious medical need, the medical need that the officers perceived was an asthma attack. So as far as any other serious medical need,
At what time do you think that was? So when did they recognize that? After they went in the cell?
After they went in the cell, but there was at least the suspicion before entering the cell that it was asthma, and that was why Berry went and got the inhaler.
You've just agreed. The district court found that they believed he had been attacked. The medical need was he'd just gotten whipped,
If we're
right? Like
talking-
if you're in prison and you believe that somebody has just gotten beaten up, isn't that a medical need?
Well, actually, what the summary judgment order says is that there was a statement the next day that there was a suspicion about whether Berry went in and was looking for any injuries and didn't want to blame anyone for anything that hadn't been done. That
I
was
totally
what the
agree.
facts were.
That's a great jury argument. I'm totally with you. But the district court,
She found that they suspected an assault.
right, they suspected that he had been assaulted, right? Suspected means like, is knowledge, right? Like,
It means a suspicion.
right. They suspected he'd been assaulted. So it's not about asthma, right? The risk here, the risk they suspected, right, was that he'd been beaten,
So I'll say,
right?
we're not.
With asthma, so maybe that makes it worse.
Well, we're not talking about a suspicion. What Farmer versus Brennan talks about is a subjective awareness of a risk of harm and disregarding that risk. That is not
And if
what
you
we-
believe that somebody's been beaten in their cell, you think that's not knowledge of a risk of harm.
No, what I'm saying is that the response to what was seen in the cell, whether the court would like to say it was asthma, whether it was suspicion of a beating, the response was to obtain medical care,
Okay, but that's a different argument, right? So the first argument is what did they know? And then we can talk about whether their response was a reasonable one, right? I totally get that. But they had knowledge, right, of a substantial risk, right? They suspect he'd been beaten.
I don't read the district court's order to say that the officers had a subjective awareness that the serious medical
They
need was
suspected
related.
he had been assaulted, and there's more than enough evidence to find that they had subjective knowledge of Mr. King's serious medical need. I mean, those are just the words. I'm just reading, right? I might not agree with it, right, if I was looking at the record as a juror, but I've got to accept that, don't I?
You have to accept the facts, and our argument is that the law as applied to those facts is where the district court erred.
Do you think that Barry and Leinster's subjective knowledge, is that a fact?
Their subjective knowledge, to the extent that the court said that they suspected an assault.
No,
the
I'm
court does
asking a
have to-
different question. Is their subjective knowledge a fact? Or is it a legal conclusion?
Their subjective knowledge would be a fact.
Okay.
So where the court erred was in the application of the subjective awareness, because there has to be that subjective awareness, but there also has to be a conscious disregard of it. So the court below also looked at the fact that Barry went to get the inhaler
Yeah, but
before
what
he went to
about
the
the
cell.
fact that when he goes to get the inhaler and he goes back to the control room and he waits because this whole thing about when he's supposed to be going to do his checks, and he sits there waiting. He's on the video looking at his watch. How is that not subjective knowledge?
It's not relevant to the question of what he knew before he entered the cell. What they knew is that there were
Is that
ambiguous
because of
noises.
getting the inhaler goes to, and I'm asking this as a question, getting the inhaler goes to a suspicion he might have some asthma problem.
That was based
As
on the,
opposed to that he'd also been beaten.
correct, that was the ambiguous noise that they heard over the intercom, and Barry's first suspicion as evidenced by the fact that he went to the nurse's station to get the inhaler. The first suspicion is that an inmate with a known history of asthma was having an issue with
A
asthma.
medical need.
Yes, the medical need was asthma. That was his, if we're taking it as this was what he knew, there's a reasonable inference to be drawn. The reasonable inference that he drew is that an inmate who had a known history of asthma was having an issue with asthma. So he
But
went to
that's
get the
just
inhaler.
flatly inconsistent with what the district court finds. I totally get that argument to a jury, that the jury should infer that his mental state was about asthma because of what he did. I totally get that argument. That is not what the district court found.
But the legal question for this court is about the subjective knowledge, because
No,
that's
no, no,
the
no.
Farmer
You just
versus-
admitted subjective knowledge is a fact question,
But
not a
Farmer-
legal question.
Farmer versus Brennan says that there has to be subjective knowledge of the risk and a conscious disregard of it. That's the Supreme Court precedent.
Right, but Judge Richardson has read this to you from the district court's opinion. Again, we might think that they're wrong, but there's been a determination that a jury could find as fact that they knew, that the two guards knew that this individual Mr. King had been beaten. So we have to start with that premise, we can't change that on summary judgment review here when we're talking about a qualified immunity issue. So with that as a given, then what is the law that applies in that circumstance that gives your clients a protection?
So the question is twofold. So if we accept the district court's finding that there was a subjective awareness that Mr. King may have been assaulted, the second question is, was there a conscious disregard of the risk? And what's clear on the record is that there was not. Whether or not Barry and Leinster thought it was asthma, we can put that aside and we can look at what was the response to what they perceived at the time.
And so on that question, you have to agree, I assume, that they, quote, intentionally delayed checking on Mr. King for some 20 minutes in order to avoid extra paperwork. So that their mental state was, we know he's been beaten, but we're gonna not go check on him now, because if we go check on him, we're gonna have to fill out a report, and that's like just a pain in the rear.
And
that's like a totally legitimate answer in your.
And I do want to be clear that it was not paperwork related to whether he had been assaulted. It was paperwork related to the round check. I think that is an important distinction to make here, and the district court did say that. It was related to paperwork related to missing the round. But accepting all of those facts.
I'm not sure if that's any better.
Is that better or worse?
That sounds worse.
I actually think it's worse.
Well, either way, the record is that they didn't want to do the extra paperwork related to the missed round if there would be extra
They knew they were
paperwork.
gonna have to do paperwork about him getting beaten up, right? They already knew that. They had to do the paperwork because they knew he'd been beaten up. They're not gonna be able to not do a write-up about him being beaten. The question is, are they gonna have to do another report about why he was beaten up?
Well, that's certainly not something that the district court addressed in the order related to that question. But getting to the question of what the response was, first of all, there's no precedent in this court saying that the 25-minute delay results in a constitutional violation. So that's first. Second,
Well, start with this premise. We're just going to assume that, and I'm staying away from the jury arguments, which could be very good. Everything with regard to asthma was fine. But then if the jury found that they knew he'd been beaten, but their only response was related to the asthma, that would seem to indicate they made no response to the beating.
Well, the inhaler response would be to the asthma, but the response was also, after seeing him in the cell, was to consult the on-site nurse, to also contact the supervisor.
Right, but I think the point would be the time period they're looking at is from the time they heard noises or worried about having to do the extra reports up until the time they actually went in and called for the nurse.
That is the time that the district court limited the review to, is that pre-entry time period, which is a 25-minute time period. So I would go back to the point that there's no precedent in this court that would establish that 25-minute delay establishes a constitutional violation to Mr. King, or that there was a clearly established right, as I expect the appellee to press, as to the thoroughness of the security rounds.
So what would happen, you're changing the facts, you've got a 25-minute period, but what if during that 25-minute period, they saw a blood trail coming out of the cell and didn't do anything about it? You can't argue that 25 minutes is a per se limit, can you?
No, you can't. If there were a blood trail coming out, that would be a very different case. Those aren't the facts before us, but that would potentially be a different case because you would have reason to know that someone is inside the cell bleeding. That certainly was not the case here. The suspicion that someone had been beaten does not speak to what the severity of that beating was, and I do realize that speaks to the fact that possibly it could have been a better course of action to go in sooner. Completely appreciate that and accept it, but on these facts, the issue is what was clearly established in 2020, and I do just want to very quickly get to the point
Let
that
me ask you this, but don't they hear him moaning and groaning or whatever, and they don't even, during their checks, they don't even go in at that point, right?
There was some discrepancy in the record as to whether it was a moan, a groan. Leinster thought that someone might
They
have
hear
asked them. So
something.
they
Yeah,
do,
they
do
hear something.
They hear a noise, and then they go and listen to it on the intercom as well.
But they don't, even though they're there, they don't even go in at that point. And they go back, they listen to it on the intercom, then he goes to get the inhaler.
That's correct.
And then they come back and intentionally wait for this 20 whatever minutes because they don't want to do the extra paperwork.
That is the factual sequence that we
Okay.
had in the court below, correct?
All right, well, counsel, you're over, but why don't you take a minute or so to move to the sheriff? And, you know, there's a pending motion to dismiss that appeal, turning on the pending appellate jurisdiction question. Give us just a brief overview of what your position is.
That this court can exercise pendant jurisdiction because the issues are inextricably intertwined between the qualified immunity question on the serious medical need and then also the Monell claim. That is based on our reliance on persuasive authority from the Eighth Circuit that states that if a right, that you can't be deliberately indifferent to a right that is not clearly established. So the argument being that under Monell, Sheriff Blackwood cannot be liable if the officers would not be liable based on the lack of a clearly established right. And one of the points I wanted to...
Right, but the qualified immunity here would apply to this known risk during that short period of time, which really doesn't relate to the Riley issue of, well, they made defective checks. So the claim here, as I understand it on the Monell side, is that there's a pattern in practice of doing this poorly. So that evidence would be different regardless of what the qualified immunity issue was with regard to the individual defendants.
I don't think it's different to the extent that the argument about qualified immunity hinges on the fact that the checks should have been done sooner or they should have been better quality checks, and that pre-entry, that better quality checks going sooner would have obviated the harm here. So in that sense, they are related from the pre-entry window to what the plaintiff appellee says caused the customer policy that caused the harm to Mr. King. Do you have a...
All right, thank you very much. You've got some rebuttal time. Ms. Sharp will now hear from you.
Thank you very much.
Thank you, Your Honors. May it please the court. This appeal is before this court under the collateral order doctrine, which allows detention officers Berry and Leinster an interlocutory appeal of the district court's determination that the evidence viewed in the light most favorable to the plaintiff leaves questions for the jury whether, which must be resolved in order to decide whether or not Berry and Leinster are entitled to qualified immunity. That is why we're here. That is the only issue that is properly before this court. The purpose of qualified immunity, of course, is to protect public officials from undue interference with the exercise of their official duties.
So rather than, sorry, not that I'm not interested in the purpose of qualified immunity, but I sort of got that part. Can you talk to me, I sort of see three different allegations of deliberate indifference here, and we've really focused primarily on the middle one, which is the delay from noise to entry.
Right.
And sort of bracket that one for a minute. I sort of understand that one, I believe. But it seems like you've also made two separate arguments. One is with respect to the checks, the failure to check inside the cell. And then second, with respect to the nature of the response after they entered the cell, right? That there are these three different sets of conduct. And I guess I'm having I very much understand your middle, you might imagine from the questions, I might understand this middle piece. What I don't understand is the first and the third after Riley. Can you help me understand what we do given Riley with respect to the failure to look in the cells and the,
Yes, Your Honor.
adequacy of the response?
Yes, and I would say this isn't about three separate claims. This is about a claim of non-supervision amounting to deliberate indifference that spans over the course of their shift.
Yeah, but you don't get to do that, right? You don't get to just say, we put all of these things in a pot and it comes out, right? We have to look at the action and inactions like as they are.
Correct.
We don't sort of do a big old pot and say, in general, it's bad. We got to look at the specific actions.
That's correct. And in response to the limitation of the 25-minute limitation, what appellant's counsel just said was that the court limited this to the 25-minute delay, which is not accurate. If you look at page 8 of.
No, but assume for a minute that I'm about to limit it to the 25 minutes. Tell me why that would be wrong.
Sure. To distinguish this case from King versus Riley, Your Honor, first of all, the fact that one of Berry's and Linster's acts or omissions of deliberate indifference is passing by Mr. King's cell without looking in happens to be the only issue in King versus Riley does not make this case King versus Riley. There's a lot more acts and omissions of deliberate indifference in this case. And
Right,
it's-
but what you can't say that failing to look in was deliberate indifference.
Well-
It might be pertinent to the 25 minutes from an evidentiary perspective, but what a jury could not find, or a court could not find, is that the failure to look in the cells itself was an act of deliberate indifference.
The deliberate indifference on the rounds is not specifically that they're failing to look in the cells. The purpose of looking into the cell is visual inspection, which is required by their policy manual. It's also
Same in Riley.
well, I don't know that there were policies that were violated.
There were
in-
policies in Riley.
Okay, so there's this policy manual that also requires responding to suspicious conduct that occurs either while you're conducting rounds or when you're in the control room. They weren't responding to any of the
We understand.
suspicious conduct.
Might be pertinent in the Monell discussion, but are you making a standalone claim that this failure to observe in the cells is deliberate indifference
No,
in and
Your
of
Honor.
itself?
No, Your
All
Honor.
right, so that's gone.
That's not the standalone claim. I believe
Well,
that.
let me ask you this, but what about, because I know Riley is not going in the cells when you're supposed to go in, and Riley says that's not deliberate indifference, but what about not entering the cell after hearing the moaning and groaning or whatever it is? She said there was noise.
Sure, but I think that gets us back to Judge Richardson's
back
point,
in
which
the
is the
25
25-minute
minutes.
delay. And what I'm trying to do for the court is expand that and explain why this is all deliberate indifference. The way that they describe, for example, Berry and Linster.
Right, but again, that may be part of your evidence, but if a jury came back with a decision on the deliberate indifference is limited to the failure to look in before the 25 minutes starts, that's barred by Riley.
Right, but we are not talking just about failure to look into the cells. There's a lot more to their rounds. We
Right, but
can't
that
even-
puts you back in the 25 minutes at that point.
No, Your Honor, if I may. When they're conducting what they're calling punches, they don't call them rounds. They call them punches. They acknowledge that the purpose of them going into the cells, it's not to conduct a supervision round. Berry and Linster both testified that they went into the cell to do their punches. The punches are.
Well, they went into the pod, not.
To the pod,
into
correct.
the-
They don't go into the
cells.
individual cells. They go into the pod to do their punches. Berry described it. He said, we only go in single just to punch. Linster, when he was deposed, I asked him, is that your definition of a round, to do your punches? And he said, yeah, that's what it means to do a round, to punch. That is it. And you can watch the videos and you can see that that is all they are focused on, is reaching those wall sensors with their electronic device and falsely documenting that they have conducted a security round, a supervision round, when they have not. Their job is to put
So you
eyes-
think that distinguishes you from Riley? That's the reason you think that Riley is inapplicable is that, or is there something else?
Riley held that it was not clearly established law that to fail to look into the cell on supervision rounds was deliberate indifference. Here we have officers who are knowingly not doing their jobs. They are knowingly violating multiple policies. They're not
Right.
responding to
So
suspicious
you're-
conduct when they're in the pod
So we
that's
don't
happening in
spend
front
all our
of them.
time on this. Are you making a standalone claim for the period prior to the 25 minutes based on these failures and going through the pod?
No, Your Honor. It's also their
All right,
behavior
well,
in.
okay, so why don't we just assume that that's out?
Well, but wait, but she's not agreeing that it's out. What
No.
she's saying is, we got to put all this in one big pot, and we just sort of call it all deliberate indifference, rather than looking at it
Right,
conduct by conduct.
There is suspicious conduct that occurs in front of Berry and Linster when they're in the pod conducting their punches, their rounds, their punches.
So
And
that,
that
you're
is
saying that's deliberate indifference?
absolutely, because this is also in their policy manual. They know that one of the jobs that they're required to do is to respond to suspicious conduct of detainees. Linster acknowledged in his deposition that he recognized at the time the suspicious conduct in front of him by detainee Bradford, and then misrepresented that he responded to that conduct, which is an acknowledgement not only that he was aware of the risk at the time that Mr. King had been assaulted, but it's also an acknowledgement that he knew he had failed to respond appropriately to that risk. He's misrepresenting that he
So did the district court
responded.
make any determination that what you've just described is part of the evidence upon which a jury could reach a verdict for the deficiency, the alleged deficiency during the 25-minute period?
The court states that there's a genuine dispute as to the officer's subjective knowledge and that there's evidence from which a jury could infer that the officers knew they were violating Mr. King's rights, and if a jury resolves that factual dispute, to conclude that Berry and Linster ignored obvious risks to Mr. King's health for over an hour before the 25 minutes, and then, upon realizing that he was in urgent need of medical care, continued to ignore him for another 20 minutes to avoid extra paperwork, that would be an obvious constitutional violation. So yes, she is also acknowledging the acts and omissions leading up to that 25 minutes. The 25-minute delay, that is possibly the most egregious piece of evidence in this case, that even after they heard, and it was labored breathing, to your question, Judge Benjamin, it was labored breathing that Officer Linster heard when he walked past Mr. King's cell. And what did he do? He continued walking. He walked right past it, knowing he hadn't looked in, knowing they had not checked on Mr. King for over an hour.
All right, let's just, we can come back to this if you want to, but let's assume that, just for purposes of argument, that the period prior to the start of the 25 minutes is out. All right, so now skip over the 25 minutes and go to Judge Richardson's third bucket, which is the response. So obviously we want you to come back to the 25 minutes. Why is the response deficient?
The response is deficient because when Berry walks into King's cell, he spends about 4 minutes in King's cell with him, and then he leaves. And you can see on the video that at first he starts to exit the pod, and then he turns around and he goes and does his punches. Instead of leaving the pod and getting Mr. King help, he's very much focused still.
So the 4 minutes was with the inhaler?
Correct. So he entered Mr. King's cell with the inhaler in his hand. He obtained that from the nurse's station before even entering King's cell. Even entering King's cell, suspecting that Mr. King had been assaulted, he's going in, he tells investigators he's going in looking for signs of assault. Linster made a similar statement to Berry. Before you go in, he's telling Berry to look for signs of assault. So this idea that they thought it was asthma is frankly, it's false. They believed Mr. King had been assaulted. They believed he was suffering an injury from assault. Berry goes into the King.
Well,
He
the
finds
two aren't
Mr.
mutually exclusive. I mean, it
That's
may not
true.
may not make a difference verdict-wise.
That's true.
But I don't think that there's anything in the record that says that they didn't suspect asthma, but that may not be particularly relevant to the beating part of it.
Correct, Your Honor.
Well, if you were going to somebody who'd been beaten, who had asthma, you would also imagine they got an asthma problem. I mean, I don't understand. You just said it's false. That seems like wrong. Like, it seems like to me, if I knew somebody had been beaten who had asthma, I would assume that they have an asthma problem because they've just been beaten, and they probably also have a contusion problem because
Sure.
they've just been beaten.
Let me rephrase. The argument, their claim that the only thing they suspected was that this was an asthma attack is false. And if you walk into a cell with holding an asthma inhaler, and you believe that you're helping
Well,
someone
from-
because
From
you,
your standpoint, not to put too fine a point on it, it's false in the sense that a jury could conclude that.
correct,
Not that they will, but that they could.
correct. And this.
Can you go
mis-
back to the third bucket? and
Yes,
just
Your
give me
Honor.
I know you got a lot on this first, the
Yes.
second bucket, and we could talk about it a lot, but
When
tell
Barry-
me why on the third bucket in light of Riley? Because in Riley, we sort of say, you ain't got to be perfect. You can continue to do your job in other ways, like other things happen, right?
Yeah.
Like, this is not a demand of like perfect efficiency.
I do think it's important to that point, though, to note that both Barry and Linster had been previously corrected or attempted to be corrected by their previous supervisor, Sergeant Whitted, who repeatedly
Why would that
told them-
possibly matter? I don't understand why that would possibly matter.
Because it goes to knowledge that they're violating.
That they're not
violating-
being efficient, right?
Not,
That they're
no,
doing.
not being efficient, that they're not inspecting the detainees. And why do we want them to inspect the
Inspect-
detainees? To make sure that everybody is safe, to make sure that everybody is
But we're-
protected?
But we're talking about the third bucket. They already know he's been hurt. I don't
They know he's
understand
been
how
hurt.
that has anything to do with the third bucket.
When-
I'm happy for you not to answer, but I'm just trying to get your answer with respect to the third bucket.
Yes, Your Honor.
And whether they did inspections at time one, like, simply is like, I don't understand why that would be plausibly relevant to time three.
When Barry enters Mr. King's cell, he finds Mr. King sweating profusely, unable to walk, wincing in pain upon any movement. He has a contusion, a fresh cut above his eye, and he's having difficulty breathing. Barry leaves the cell, and again, instead of leaving the pod, he goes and finishes his punches. He goes to the control room, and at some point, a nurse is called. He tries to call a nurse according to his report. She doesn't answer. Barry and Linster then take 10 minutes. They wait 10 minutes before going back to Mr. King's cell. They leave the door wide open, suspecting he's been assaulted by someone in B-Pod. They go back to King's cell with another detention officer, Gomez, and then they take, between the altercation and the assault on Mr. King and the time they exit B-Pod with Mr. King, it's 2 hours and 17 minutes. 2 hours and 17 minutes between
Right.
those two times. They take time to
So just
dress
your
him.
answer is like, you can't just address the third bucket. Your
I
view
am.
is that like.
They did
that-
not
that they
call
have to be
EMS.
put into a big cauldron and sort of mixed together.
No, Your Honor.
Right, because the 2 hours is obviously before even time one bucket, right? Like, that's when he's assaulted, which is before they went around, which is before they waited 25 minutes, which is way before the bucket we're trying to talk about. But your distinction is that.
1 hour and 8 minutes, Your Honor, between the time they hear the labored breathing and the time they take Mr. King out of B-Pod. It's 1 hour
So
and
the
8
distinction
minutes.
between the start of the second bucket and the end of the third bucket is that's the time period you want me to focus on. 1 hour and 10 minutes. The start of the second bucket to the end of the third bucket.
Your Honor,
I'm happy to focus on that. I'm just trying, I want to make
think-
sure I understand your argument. That's all.
Because you've already said, you understand the 25 minutes, then I'm just saying that additional time, we're talking a total of 1 hour and 8 minutes. Barry
And that's
leaves
the start of the 25 minutes until
Cor-
what?
Until Mr. King is finally taken out of B-Pod. The policy tells the detention officers that when they find someone in a medical emergency, they are required to evacuate the pod and call EMS. They did not do that in this case. They recognized, both Barry and Linster admitted in deposition that they recognized this was a medical emergency. When they were asked why they did not call EMS, neither of them, they gave various answers. One was, that's really not our
But
job.
they did report it to a supervisor, and they did get in touch with the nurse, and they were taking steps, whether it's changing his clothes, getting a wheelchair. All of that could well be negligence, but negligence is not deliberate indifference. So why is this response, starting at the time that one of them goes in the cell and actually observes him, until they depart the pod, why is that part deliberate indifference?
Because having acknowledged in deposition that they recognized there was a medical emergency, they instead treat this as if it's a routine trip to the nurse. There is absolutely no urgency. There is absolutely no effort to call for EMS to make sure that his emergency medical needs are met. They are slow walking it, Your Honor. They take time to put him in a fresh jail jumpsuit. Why? Why wouldn't you just immediately get this man to a hospital? And the appellant's brief
But again,
focuses.
why is that deliberate indifference as opposed to negligence?
Well,
Maybe even gross negligence, but that still doesn't get you to deliberate indifference.
Well, I think that it goes to answer that, we have to look at what their mental state was, because that's what deliberate indifference is really about. And that's why it's important to consider all of the evidence in this case, because
Right, but it's two steps, okay? We've already gone through their state of mind, all right, first step. And the second step is, well, what did they do about it?
and they slow walked it, Your Honor. They treated this as if it was a routine trip to a nurse.
Because they don't, I mean, based on the timeline, they don't call EMS until 9:06. They go in at, what, 8:13?
That's correct, Your Honor. That's correct. And it was the nurse who called EMS pretty much immediately upon seeing Mr. King. And I suspect my colleague here is going to argue that, you know, even the EMS workers didn't know this was a medical emergency when they saw him. But that's actually not true. Based on their declarations, they were very concerned about Mr. King. They said it looked like he may have suffered a cardiac event. They immediately did a 12 lead and took him to the hospital. The nurse, as soon as she saw him, she said he was in and out of consciousness. He was unable to walk. He had this fresh contusion above his eye, and she immediately dialed 911. But again, Barry and Linster both acknowledged in deposition that they believed Mr. King was suffering a medical emergency. And they failed to respond appropriately to that. They didn't respond at all. They didn't respond in line with the emergency
Well,
medical
why do
plan.
you say they didn't respond at all? I mean, it may have been woefully deficient, but they were taking actions all through that period. It may have been wrong, may have been negligent,
They responded.
but to cross that line to get to deliberate indifference would seem to take something more than just, well, they chose the wrong steps.
They chose to ignore his emergency medical needs and take him to the jail nurse as if this was a routine medical visit.
They waited 43 minutes before they called EMS.
And wait 43 minutes without, and again, they did not call EMS, which was their
Right,
job
because
according to the policy.
they contacted the nurse.
Well, the policy
And
manual.
then the nurse is the one that elevates it. I mean, listen, maybe you think that's like not a good thing to do, but I don't know, if somebody's like, looks like they're hurt and I get a nurse, it's a little hard for me to think like, actually, I'm gonna need to overrule the nurse here. I think we need to do something different than what the nurse is suggesting or doing.
Well, it's not just that I think it's not the right thing to do, Your Honor. It's from Short versus Hartman, page 613, which tells us, though a violation of a local policy does not by itself violate the Constitution or give rise to a Section 1983 claim, it is nevertheless instructive both in determining the seriousness of the risk posed and in determining whether an officer knew of the excessive risk posed by the official's action or inaction. There are a number of policy violations in this case, Your Honor, that did not exist.
What is the policy that says when you find someone injured, you are not supposed to contact the nurse, but somebody else? Where am I looking at that?
I see my time is up. May I answer?
I'm sure you can answer.
Go ahead.
Thank you. The policy is the medical emergency plan, Your Honor.
So you gotta know it's an emergency, but
No.
where am I looking at? Just give me the JA. All I'm looking for is the site. I can read it. That's all right. I can find it.
Or you
More
can-
directly, my clerk can find it.
Or you can send that to us in
I
a
will send it,
28J
I will send it to Your
letter.
Honors. And the difficulty breathing was actually listed on that emergency medical plan as a sign and symptom of a medical emergency for which the detention officers were required to call EMS.
All right, before you sit down,
Yes.
same thing we ask of opposing counsel. Take a minute to tell us about the Monell claim.
Yes, Your Honor. Your Honor, opposing counsel acknowledged in her argument that the district court applied the Eighth Amendment to deny qualified immunity to Barry and Linster, and that's exactly right. And so for that reason, the Monell claim is in no way inextricably intertwined with the evaluation of qualified immunity. Qualified immunity was evaluated clearly by the district court, despite appellant's brief suggesting otherwise, was evaluated under Eighth Amendment standards. And the Monell claim was evaluated under 14th Amendment standards. So they do not depend on each other in any way. You can't appeal a Monell claim until there's a final judgment. We're here on qualified immunity only, and it is not connected at all to that Monell claim because we're looking at completely different standards, because that's what the district court did.
To understand that, can you tell me what is the Monell policy? What is the policy or practice that you're alleging?
It's a custom and practice of non-supervision, Your Honor, and that is what
What
the
not,
district-
what do you mean by non-supervision? Tell me,
a complete lack of supervision. So not
supervision,
Of
but
the
supervision
detainees.
can happen, right, okay, two different ways, right? Of officers or of detainees?
supervision by the officers of the detainees. So failure to conduct any meaningful supervision rounds, only being focused on doing your punches, not watching from the
You think that
control
was the
room.
policy that the sheriff had knowledge of? You're gonna say that,
Absolutely, and there is evidence from Sheriff Blackwood's deposition testimony that he was aware that his officers were actually not visually inspecting the detainees just, I think, 6 weeks before Mr. King was assaulted, and that awareness came from jail inspectors' reports that notified him of these deficiencies, that his officers were being found not to be visually inspecting the detainees on their rounds repeatedly. I think there were 6 notifications that he was given.
So your view, if I can go to what I perceive to be the bottom line, is that even if the individual defendants prevailed on qualified immunity, the issues with respect to the Monell claim are different and not determined by the qualified immunity finding.
That's correct. And with regard to the 8th versus 14th Amendment issue, because I know appellants tried to argue that the district court relied on 14th Amendment standards in the qualified immunity analysis, which is not accurate according to her order. And so they used that to try to argue that the 14th Amendment standards are inappropriate here. And I do just want to say that that is not an issue that's properly before this court. It would expand the collateral order doctrine. But if and when that issue does reach this court, I believe that the 14th Amendment standard is appropriate, which is what both the magistrate judge and the district court judge found in this case. And the reason for that is that at the time of conviction, there was a 10th Circuit case, City of Muskogee, that found that at the time of conviction, the state acquires the power to punish, and that is incorrect. That's simply incorrect. The state does not acquire the power to punish until sentencing, because that's when the sentence has been determined.
All right, I think we've got the gist of that, so thank you very much.
Thank you, Your Honor.
And we'll turn to Mr. Castro. Are you the one who's going to do rebuttal? Yes, sir. All right, come on up.
Thank you, Your Honor. I wanted to begin by responding to the first batch, as we were calling it, of the facts regarding the non-supervision, which are undisputably analogous to King v. Riley. I believe at worst, at minimum, the court should disregard the facts regarding the rounds that were conducted prior to the assault, all of the time period prior to them hearing a sound or
What
being-
about Barry's testimony that he suspected that there was an assault occurring during his rounds? Isn't that different than Riley?
I'm
Riley
not-
was just more of a, we didn't look in, we did our rounds, we just didn't look in.
I'm not sure that was what he testified as to. I believe he was referring to the point where they heard the moaning when Linster was coming back from his second round, where they heard moaning or labored breathing at that time was when they were discussing whether there could have been an assault. I'm not sure there was a suspicion or any testimony as to a suspicion during those rounds that he suspected an assault. The video demonstrates that the inmates were, standing in front of the cell, concealing their actions, pointing the detention officers away from the cell. The period that occurs prior to them, Linster hearing a labored breathing, is fully dependent on plaintiff's arguments about they were standing around in the control room, not looking at the cameras.
what about the Bragford point? Your colleague says that one of the two guys, I can't remember which, was suspicious about Bragford on the rounds before, and that was before the concerning noise. It's gotten a different name in a lot of places, but I think the district court refers to it as a concerning noise.
This concern, from my reading, and I believe this is accurately reflected in the record, is that Grants was a dangerous inmate. That is undisputed. He had a past history of assaults. However, there was no, at the time of the rounds, there was no suspicion that an assault had occurred. The general knowledge of his dangerous predisposition, perhaps, is insufficient to to rise to actual knowledge or subjective knowledge under Farmer v. Brennan under the failure to protect dichotomy. The courts have continuously stated that there must be a specific inference made that that specific inmate poses a risk to King. Grants did have a past of assault to behavior, but that is not, Linster, I do not believe that he testified that during his rounds he suspected that an assault had occurred at that time. It was generally the fact that Grants was a problem inmate, if that can be a term. Regarding the response, as was noted during opposing counsel's argument, the detention officers relied on the nurse. It was 8:10 p.m. when they first entered the cell after the labored breathing, after they heard the sounds. It was 8:24, 14 minutes later, when a wheelchair arrived. They called for the nurse, they called for a wheelchair, and it was 8:53, about 43 minutes later, where he was carried out to the nurse's station. The nurse then
How
called
much
EMS.
time elapsed between the entry to the cell and the call to the nurse?
That is unclear, but at minimum, it would have been in the range of 15 minutes, because that is a moment where the record reflects that a call was made to the nurse and the wheelchair arrived, according to the timeline, the undisputed timeline. It was around the 8:24 to 8:30 mark when the nurse would have been called. And thereafter, the wheelchair arrived around that same time. He was carted out to the nurse's station, and courts have continuously stated that detention officers are entitled to rely on medical personnel in responding to a medical emergency, which is what they were doing. Therefore, we believe the
Well,
response.
does the record show when the nurse actually arrived?
Regarding the nurse,
Well,
yes,
did
the record
nurse
does show that.
Did the nurse actually go into the pod, or was it the entrance to the pod?
The nurse is shown at 8:45 entering the hallway with Barry. She's not part of the actual direct participation in the response. That is all occurring after the nurse is initially called, which there's no record of specifically when that occurred. I wanted to briefly, since my time is running out, go to the.
So what's the first time that you see the nurse?
We see the nurse on camera with Barry at 8:45. This is after it is the testimony that the nurse was called, the wheelchair was rolled out. As I noted, they heard the breathing at 8:10, and they arrived with the wheelchair 14 minutes later at 8:24, and then the nurse eventually calls EMS. They were entitled to rely on the nurse's opinions as to the medical emergency. Going briefly to the Monell claim, King was not a pretrial detainee, and he was not entitled to the 14th Amendment analysis. Therefore, if the court is to analyze this case under the 8th Amendment applicable to the individual defendants, then it is directly intertwined with the Monell claim. He was a post-plea, pre-sentence prisoner, and the Supreme Court of the United States has clearly stated that a plea is a conviction, and once someone is convicted, they are entitled to the concept of punishment under the 8th Amendment.
Tell me why, as a factual matter, what is the factual intertwining that is necessary here? Like what is, because, one's about a policy, right? And you can have qualified immunity and the Monell claims still apply. They're not like mutually exclusive. If you get qualified immunity, hypothetically, that doesn't mean the Monell claim goes away, or vice versa?
It does not necessarily mean that. However, there are two prongs to the qualified immunity analysis. As Your Honor mentioned, if you're ruling simply on the clearly established prong, that there was no clearly established violation, there is a chance that the sheriff's claim can proceed, albeit it should proceed under the 8th Amendment, we believe. However, if the court is to rule that there was no underlying constitutional violation under the secondary saucier prong, then the sheriff's claim must necessarily fail, because a Monell claim cannot proceed absent an underlying constitutional violation by an individual. That is why.
So you agree, if we were to find, hypothetically, that there is some constitutional violation by these two defendants, with respect to the plaintiff, then we would not then address the Monell claim.
You should address you would not be required to if it was under the clearly established prong of the
No,
qualified
no,
immunity.
no, but what I said is, if we find there was a constitutional violation, right, by the two defendants, then we should not then address the Monell claim, because there wouldn't be an inconsistency there.
There would not be an inconsistency, but there would still be a legal error by the district court in the application of the 14th Amendment, however, which should be clarified on appeal. But there wouldn't be an
There
inconsistency.
would be a legal error, tell me that one more time, and then I'll stop.
The legal error would be applying the 14th Amendment. In your hypothetical, if you were to
Oh,
find.
because you think the Eighth Amendment starts to apply before someone is sentenced?
Correct.
Okay, all right,
And
I understand. Thank you very
That's the
much.
only difference.
All right. Thank you very much. We appreciate the argument of all counsel in this case.
Thank you.
And we're going to come down and greet counsel, but ask the clerk if she'll adjourn us for the day.